All right. Can you search a vehicle under the motor vehicle exception if half the car is on curtilage and half the car is on open fields? All right. My name is Anthony Bandiero, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing you to the roadside chat. This question comes from an officer in Missouri. Look, the officer says, we know that you have to get a search warrant to seize and search a vehicle that's on private property, curtilage, right? But what happens when the vehicle is on half on an easement, right, or the sidewalk, and half is on curtilage? And my officer gives a lot of different scenarios, but I think it just comes down to, even if the person, sometimes they'll own property. Let's say but it's not curtilage, right? Let's say that you have a driveway, then you have the sidewalk, and then you have some more like grassy area. They're required. That's probably their property, right? But they're required to mow the lawn and so forth and trim the trees. But the courts are not going to consider that curtilage because there's no exclusive right of access there. It's the public can be there to walk their dog and so forth. What about those cases? Well, I have no case that specifically talks about it, but I think, quite frankly, I think half the car is searchable and half the car is not, right? So let's go back to our seminal case on this issue, which is Collins v. Virginia. And what it says here, in physically intruding on the curtilage of Collins's home to search the motorcycle, the officers not only invaded Collins' Fourth Amendment interest in the item searched, the motorcycle, which we can probably get over with the motor vehicle exception, but also invaded Collins's Fourth Amendment interest in the curtilage of his home. The question before the court is whether the automobile exception justifies the invasion of the curtilage. The answer is no. Right. And also the reason is that the scope of the automobile exception extends no further than the automobile itself. So you don't get the area around the car under the motor vehicle exception. So strictly speaking, if we look at this from a legal point of view, if the back of the car was on on open fields, right, not curtilage, even if they technically own it, it has to be curtilage. And the trunk, let's say the trunk is on that portion, and the cop opened up the trunk and found drugs based off of probable cause. I think push comes to shove, those drugs should be admitted, right? They shouldn't be suppressed because it does not violate Collins. But then if the officer moves towards the front of the car, the portion on curtilage, the driveway, and finds more drugs, then I would say those drugs probably should be suppressed because you don't have the lawful authority to go onto the curtilage with these facts to search. The motor vehicle exception doesn't give you that. And I gave you no exigency, I gave you no consent, and I gave you no warrant. So there's no other way to get the other portion of the car that is on curtilage. So it's a funny case. You win half of it, right? Half the car on curtilage, off curtilage is going to be probably fine. And half of it on curtilage is not going to be fine. So what's the takeaway? Get a warrant, right? Get a warrant because the courts are going to be so confused by this argument. You're probably confused by this argument. Like, Anthony, I don't. So we got to get a measuring tape out. And I'm like, I guess, right? It's just going to be so convoluted if we go to court on this one. Get a warrant. All right. I left the case in the description below. I hope it helps. Before you leave, if you wouldn't mind, like, subscribe, comment, share with your friends, and I'll see you guys next time.